So I'd like to welcome everyone to this Employment and the Law webinar, which is part of our webinar series for Law Week 2023. Before we begin, we would like to acknowledge the traditional owners of the land from which we are broadcasting today. I'm broadcasting from the lands of the Gadigal clan of the Dharug Nation. We pay our respects to their elders, past and present, and we extend our respect to any First Nations people participating today or watching the recording. Good afternoon, everyone. My name is Christina Nashi, and I work as a solicitor in the Community Legal Education branch at Legal Aid New South Wales. Today's webinar will be an hour in total, including some time for Q&A at the end. You'll also receive an email about some of the resources that we referred to in the webinar today. There is a handout which will be uploaded in the chat towards the end of the webinar that you can download. But if you're in a library today, you might have access to a paper copy of that handout as well. So today's webinar is a panel discussion about employment and the law, where we will be discussing your rights at work with a focus on discrimination and sexual harassment laws. Today's aim is to provide general information on this area of law, not to give specific legal advice. I will now introduce you to our panel members for the discussion today. I'd like to welcome Lucy Carroll from Merrickville Legal Centre and Fiona Pace from Legal Aid New South Wales Respect at Work Legal Centre. Welcome, panelists. Would you please let us know a little bit about the work that each of you do in your particular services? Lucy, perhaps we'll start with you.
Yeah, of course. Thanks, Christina, and thank you everyone for attending today. I'm the Assistant Principal Solicitor at Merrickville Legal Centre. We are one of many community legal centres in New South Wales, so while we may not be the one that covers your service area, we all do offer similar services insofar as providing free legal advice and assistance to those members of community who may not be eligible for legal aid due to criteria or may not be able to afford a private lawyer. So I work in our employment law practice at MLC. We do a lot of advice on all areas of employment law, but do spend a lot of time as well with advising and assisting clients in relation to discrimination and sexual harassment matters.
Thanks so much, Lucy. Fiona.
Thanks, Christina, and good afternoon, everybody. My name is Fiona Pace. I am the Senior Solicitor in the Respect at Work Legal Service, which is a new specialist service that is part of Legal Aid New South Wales. Our service has recently been set up to help people all over New South Wales who have experienced sexual harassment or discrimination in the workplace and to deliver education to the community on these issues. Our Respect at Work Legal Service team is spread out throughout New South Wales, some of us in Sydney and some in regional areas as well. And as well as the Respect at Work Legal Service, Legal Aid New South Wales also has other lawyers specialising in employment law and human rights law, based in both our Sydney and our regional offices all over New South Wales.
Great, thanks. Thanks, Fiona. So we'll start with a question for you, Fiona. Firstly, for our audience, what is unlawful workplace discrimination and harassment?
Unlawful is a legal term that lawyers use. And essentially it means when something is against the law or something is covered by our laws. That's what lawyers call unlawful. In terms of sexual harassment and discrimination, we have different laws in Australia. We have Commonwealth discrimination laws, which cover everyone in Australia. So you've probably heard of legislation like the Racial Discrimination Act, the Sex Discrimination Act, the Disability Discrimination Act. We also, in New South Wales, those in New South Wales, we also have New South Wales discrimination laws that cover everyone in New South Wales. And that law is called the Anti-Discrimination Act. And these laws, all of these laws combined, define what unlawful discrimination at work is. So those laws really cover all types of workers and visitors to workplaces as well. And most of them are covered. So that includes people applying for jobs, what happens to workers once they're doing a job, and workers who lose their jobs as well. The laws cover casual employees, permanent employees, contractors, volunteers, and visitors to work sites as well. So in terms of what those laws say unlawful discrimination is, really unlawful discrimination is about either a job applicant or a worker, someone being treated differently in a workplace, one worker being treated worse than another or harassed than another worker, and they're treated unfairly, or they're treated badly, or they're treated worse because, and this is really important, because they have a disability. So, or because they are a man or a woman, which is sex discrimination, or because of their race or cultural background, or because of their sexual orientation or transgender status, or because they are married or single, or because they're considered to be too young or too old to do something, or because they're pregnant, because they care for other people. So parents caring for kids, people caring for other people such as parents, or they're treated unfairly because they know or associate with someone who has one of those characteristics. So someone who has a disability, or someone who is gay, or someone who is Aboriginal, etc. So really, when we're talking about unlawful discrimination, we're talking about where people are being treated differently and unfairly to another worker who does not have that disability, or who is not a carer, etc. So some examples are, might be a female worker who's being told that she can't do certain physical work tasks that male workers are allowed to do. So you have this this difference in treatment. Another example is an Aboriginal person doesn't get a job they apply for because the owner of the business heard someone on TV say that Aboriginal people are lazy, and they give that job to a non-Aboriginal person. Or another example is if a woman returns to work after having a baby and taking maternity leave, and when she gets back to work, or where she tries to come back to work, a male worker has taken over her job. She's given a different job title with less meaningful work, maybe less pay. That's another example. Or another example might be for if someone with a physical disability, for example, is told that they have to stay out the back of a business, and that they can't serve customers. And another worker who doesn't have a disability has to do the frontline customer service. So there's some examples of discrimination. Our laws say that there are two types of unlawful discrimination at work. One is called direct discrimination, and really that's where the unfair treatment it's kind of obvious, and it's directed at an individual worker, someone who has a disability, or someone who is of a particular race, racial background, etc. So it's directed at a particular person. So some examples might be racist jokes being told in front of an Aboriginal worker, or a woman being asked at a job interview if she plans to have kids, and then she's not given the job. Or a worker caring for a sick family member, they're not given sick leave, or they're fired from their job because they took time off to do that caring work. So that's direct discrimination. Our discrimination laws say that is one type of unlawful discrimination. And then the second type of discrimination that the laws cover is called indirect discrimination. And this is a bit more complicated and a bit trickier to identify. But if you strip it back, then essentially it's where a workplace has some sort of rule or policy that everyone at work has to follow. So it looks like it's neutral, but the effect of that rule is that it impacts badly on certain groups of workers. So some examples might be where team meetings are always held during school pickup and drop-off times, when those meetings could be held at a different time in the day. So having those meetings at those school times impacts badly on parents who have school kids, but not other workers who don't have kids. So again, it's that difference in treatment, and it's where certain rules impact certain groups differently to other groups. Another I guess one of the first indirect discrimination cases, one of the most famous ones, and it kind of demonstrates it well, is that if a certain industry has a rule that you have to be of a minimum height to work in a particular industry, and there's no good reason for that rule, basically. So one of the first cases involved firefighters. So the fire service had a rule that everyone had to be a minimum height in order to join the fire service. And what that meant, the result of that, was that women, who tend to be shorter than men generally, weren't able to join the fire service, and people from certain ethnic backgrounds also weren't able, who again generally tend to be shorter, they weren't able to join the fire service. So indirect discrimination can be a bit harder to identify. But I guess what I would say is, if you see some rule or policy or system at work that is affecting some people badly and not others, and it seems unfair, it just feels unfair, then I would say just get some advice. So discrimination and harassment can be a one-off experience. It can be one event, or it can happen over a long period of time and be lots of things. Can be very obvious or very subtle. The other type of discrimination, and something that our laws cover and says is the laws say is unlawful, is sexual harassment, which I'm sure you've all heard of, particularly in the media lately. And basically the law says that sexual harassment is any unwelcome sexual advance, or any unwelcome request for sexual favors, or any other unwelcome conduct any unwelcome behavior which has a sexual nature. So sexual harassment, it might be unwanted physical touching, it might be comments or jokes made to one worker or a group of workers. It could be asking a worker out on a date, particularly if it's a boss asking an employee out on a date. It could be pictures in the workplace. So if someone has a screensaver on their computer, or a poster or a cartoon in the workplace, and it has something sexual in it, that can be sexual harassment as well. And then, of course, if we go to the more serious end, then sexual assault as well. If people say it was a joke, I didn't mean it to be offensive, it doesn't matter. That behaviour is just unacceptable in the workplace, and the laws say so. The other important thing I think to mention in terms of our discrimination laws, and where we're talking about the workplace, is victimisation. So this is something that is covered by our discrimination laws, and we often see where someone has been discriminated against or sexually harassed, that they've also been victimised. So basically, victimisation happens when a worker complains about discrimination or harassment. Now, that might be making a formal complaint, but it also might be making a passing comment that, they might complain, or that somebody's discriminated against them. And then because of that complaint, or because somebody thinks that they might complain, they are punished because of it. So the sorts of examples we see is where a worker's shifts are reduced after complaining, or a worker gets fired, or a worker is ignored or ostracized by other workers or bosses, or suffers bullying, etc., after they've complained or raised an issue. Or it might be that a worker who complains is moved to a different work site, but the worker who they complained about doesn't really suffer any consequences and is kept in the workplace. Those are the sorts of things that we say are victimisation, and are also covered by the law.
Thanks for that, Fiona. Can you please give us an example of someone who experienced unlawful discrimination or harassment in the workplace who you have assisted?
Certainly. So most recently, I can talk about a sexual harassment matter that one of the lawyers in the Respect at Work legal service team dealt with. And so our client was a woman in her 20s. She was working as an assistant for a director of a small business. That director, who was also her boss, basically groped her at a work function and asked her to go to a strip club with him. Not that this necessarily matters, but this man was married and his wife was also associated with the business as well. I guess it just gives a bit of context. Now, this worker, after these events happened, she was still working for this man. Very bravely, she raised it with him at a performance review. And after she raised it with him, he blocked all her access to business emails. Now, she was very upset by the harassment and also by the way she was victimised after she spoke up about it. Now, she felt that she couldn't continue working with him. And so she offered to leave the company if he paid her 4 weeks' wages. She then came to us for advice, and we talked her through all her options, legal and non-legal options, including making a formal legal complaint. Now, she didn't feel this had impacted her, these events had impacted her quite badly, and she didn't feel like her mental health could handle making a formal legal complaint, and she just wanted it all over as soon as possible and to move on, be able to move on. So what we did was we offered to help her negotiate a fairer result, a fairer outcome with that employer. So we removed her from having to we took over those negotiations for her so that she didn't have to deal with the harasser again. And so we helped to negotiate a deal to better compensate her for the harm done to her. And that harm was her losing her job that she'd loved before these events took place, but also the impacts on her mental health. So we took over all communications with the employer so that she didn't have to, and we negotiated with the employer until he agreed to pay her the equivalent of 12 weeks pay, and also provide her with a written reference about her good performance, etc.
Amazing, thanks for that. So Fiona, what is not considered unlawful discrimination?
Okay, so as I mentioned earlier, unlawful discrimination is where the laws cover a situation, but our discrimination laws don't cover all unfair treatment that happens in life, only some situations. And this is, it's certainly not fair necessarily, but, our laws, it's just the way it is. They only cover certain types of discrimination. So some examples of where someone might experience discrimination, but the laws don't cover them, are, for example, where you're not considered physically attractive enough to get a job. So physical appearance, how you look, is not covered by our laws. So someone can discriminate against you based on how you look, and the laws are not going to protect you. That's one example. If you get treated unfairly at work, or you don't get a job, or you get bullied at work, whatever the unfair treatment is, because someone doesn't like you, and the reason they don't like you is just because of a normal personality conflict. We're human beings. Some people just don't like each other. But the reason they don't like you or treat you badly is not because you have a disability, or is not because you are a man or a woman or from a particular racial background, but they just don't like you for a different reason. Then again, that's not unlawful discrimination, and the laws are not going to cover you. The other thing I would say is that there are, I don't think it's very helpful to go into it now, but I did mention that we have two sets of laws in Australia. So we have New South Wales laws, and we have a whole lot of Commonwealth laws that cover discrimination. And there are a lot of technical legal differences between those laws. And so, for just one example, is in some situations in New South Wales where if you're a worker in a small business, with 5 employees, basically, then you're usually not going to be covered by our discrimination laws in New South Wales, but you will be covered by our federal laws. So, as I said, I don't think it's helpful to go into it anymore, but just to be aware that there are technical legal differences between the laws, which might mean that sometimes you're covered under some under one law, under one system. Sometimes you're covered under the other. Sometimes you're not covered at all.
Wow. So Fiona, what outcomes can a person get from making a discrimination or sexual harassment complaint?
Well, there are a whole lot of outcomes available. The good thing about using our discrimination laws is that you can be really creative in what you ask for. And we've seen some incredible outcomes over the years. So, I mean, if you want to keep your job, then that's one outcome. If that's appropriate and that's what you want. And that might mean keeping your job but working at a different work site, for example. But if you want to keep your job, that is certainly one possible outcome. It might be getting a promotion you were knocked back for. It might be getting an employer to agree to things that you want to happen or to change in the workplace. So again, it might be getting transferred to a different work site. It might be working different hours to what you're doing, or getting those team meetings changed to a different time of day, for example. You might want the person who's treated you unfairly or the person who's harassed you disciplined or trained or removed from the workplace. That's another outcome that you can ask for and get. You can get an employer to introduce discrimination and harassment policies. I mean, it's unusual for these days for employers not to have a policy, but you can. Some of the policies aren't good enough, and so you might want changes to the policy or get a policy introduced. You might want an employer and be able to get an employer to train staff about discrimination and harassment and do the training better and more regularly, for example, so that people in the workplace know their rights and they know what they can do when they feel discriminated against or harassed. And so that, and the other sorts of, it might be training about discrimination and sexual harassment, but other types of training are outcomes you can also ask for. So, for example, disability awareness training or cultural safety training. And you can ask for things like, we recently helped someone with a case where, and it was in a regional location, and the employer agreed to introduce Aboriginal cultural awareness training in the workplace, but we made sure that that training was delivered by somebody local from that area, so that it was really targeted training and really relevant to that region, specific to that region, rather than the more generic training that might be available. So the other thing you can ask for and get is an apology. And financial compensation is another outcome. Now, you can ask for financial compensation for any lost wages, and that might be wages that you've lost already, or it might be future lost wages. So if it's going to be hard for you to find a job because you live in a small area, because you work in a particular industry where jobs are hard to come by, or you're just really badly affected by the discrimination and harassment, and so you're not in a place mentally where you'll be able to find a job for a little while, then you can get future wage compensation for future wages as well. You can get compensation for the harm done to you and how it made you feel and how it impacted you. So the psychological harm, and you can also ask for your medical expenses to be reimbursed. And again, anything you've kind of paid out in the past, it might be getting counselling, seeing a psychologist, medication, etc. But if you're going to need to do that for the next 6 to 12 months, for example, then you can ask for that as well. And lastly, I would say that, and in my experience, helping people with discrimination and sexual harassment cases, it's a way to express to the person who treated you badly. It's a way to express to them how the behaviour is wrong, how it made you feel, how it impacted you, and in my experience, that is the best outcome that people get from taking action. It's empowering. They find it empowering, and it's an important part of healing for most people. And it's really powerful, I think, as I said, the person who's done the wrong thing to hear that. I think that in itself might change their behaviors in the future. So, so people get individual outcomes that help them, but they also get changes that that help others in the workplace or help others in the community more generally.
Oh, great. Thank you. Thanks so much for that, Fiona. Lucy, so just going to you, are there any deadlines or time limits to take action or to make a complaint about discrimination or sexual harassment?
Yeah, there are. And I think it's building off of what Fiona's already covered, with those different sets of laws that we have that cover discrimination at both the federal level and at the state level. They have different time limits that apply to different types of claims. So this is where it's really important that if you think you might have a claim, to ensure that you act relatively quickly if you're thinking of taking some kind of legal action, but also getting some advice from any of the services that cover this area of law, to ensure that you don't miss out on those deadlines. So I'll keep it quite high level, and we'll kind of go, if there's any further questions later on, we can go a bit deeper into them. But I think it's also important to understand the different bodies that also cover the different types of complaints you can make if you feel that you've been discriminated or harassed at work. So the most common one that we hear about is the Fair Work Commission. They are one of the bodies that operate in Australia for you to make complaints against employers for certain things. The ones that do cover areas of discrimination law have a 21-day time limit if you've been dismissed. And so that's where it's one of the shortest time limits of the claims that are available. And it's really important to ensure that if you do think you might have a claim and you've, say, seen that that discrimination or that sexual harassment or anything related to those things eventuate in a dismissal, that it's really important to act quickly and to get that advice, so that if that is a claim that is suited for your situation, that you can make it within that 21-day time limit. Other claims in the Fair Work Commission that don't have such a tight time limit are other discrimination complaints that you may have experienced during the course of your employment that didn't necessarily relate to a dismissal occurring. That's things like Fiona's mentioned, where, say, your job changes, your pay changes, you're put out the back, or you're missing things at work and treated differently because of the protected attribute that that you have. So there's a 6-year time limit on those claims. It does give people time to think about weighing up their options, getting advice, taking steps to work through what they want to do in relation to the situation they're in. So there is time there available to work with for that type of claim. A more new stream of complaint that the Fair Work Commission hears is called a stop sexual harassment claim. So this is something that's come in quite recently for the Fair Work Commission, and they have a time limit of bringing the claim within 2 years of the date of the last alleged harassment occurring. They acknowledge that harassment may be continuous and may evolve over time. So there is, I guess, that time limit attaches to the last allegation that you're making. So separate organisations and entities that do help with discrimination complaints, there's 2 others. So at a state level for New South Wales, we've got the Anti-Discrimination New South Wales entity. They have a time limit of 12 months from the date of the discrimination occurring. So still a bit of time, but obviously a time limit nonetheless to keep in mind. And the last one that exists is the Australian Human Rights Commission, and their time limit is 24 months from when the discrimination occurred.
Great, thanks for that, Lucy. But what happens if a person misses the deadline? What are their options then?
Yeah, sure. So again, because they're different bodies that handle the complaints, they have different ways that they'll deal with if you've missed a deadline. So the Australian Human Rights Commission and Anti-Discrimination New South Wales can still accept your complaint if you give them good reasons why it's late. So say if you're outside of that 24-month time limit or the 12-month limit for the Anti-Discrimination New South Wales, it's really important that try and make the complaint as quickly as you can within your circumstances, but ensure that you put those reasons as to why there was a delay in the complaint form, and kind of set out what that is, albeit personal reasons, health reasons, or, for example, trying to resolve things without taking legal action. If you put those in there, they do have the discretion to allow the complaint to proceed, even if it is outside of time. It's also important to kind of think about, well, would this disadvantage the other side, bringing it a lot later in time, and just kind of thinking about those reasons why this might be problematic if it was let through after the time limit has passed. If they're medical reasons, really important to support that with some kind of medical evidence if you have it, but if not, just kind of explaining what you've been going through in your complaint itself. In practice, particularly the Australian Human Rights Commission, they'll generally accept your complaint even if it's out of time, but maybe later on as it progresses, they might then consider like, why was it out of time? Similarly with Anti-Discrimination New South Wales, but if you've got those good reasons for why there was a delay, they're more likely to consider letting that through in any event. So something to keep in mind. The Fair Work Commission, with particularly that 21-day time limit, because it is so short, you do have to, I guess, address it separately as to why the application was made outside of time. So that's one where you'd really want to make sure that you've got those examples of what were the reasons to the delay set out, and there is a threshold of them being exceptional or unusual in the circumstances. So that's one where, say, if you were at 22 days, it would be good to get legal advice just to make sure that you do have good reasons for seeking that extension of time to file your claim anyway.
Great, thanks, Lucy. So what should a person do if they think they've been discriminated against or have experienced sexual harassment in the workplace?
Yeah, really good question. So if you think that you've been discriminated against or experienced sexual harassment in the workplace, there's a few steps that I think are really important and do apply to most issues that you think you may be experiencing in the workplace. They're quite universal. The first one is to make sure that you keep notes or a diary that sets out the dates and times and people that were involved and the people who may have witnessed the conduct. That's really important, particularly if these incidences occur over time, or maybe start really subtle and you go, that didn't really sit right with me, but I'm not sure what it is yet. Good to keep those things noted down so that if you do then find that there is a pattern of this behavior in the workplace, that you can then go, okay, I can actually look back at how this has evolved and what happened and who was there when it happened. So really important to try and keep those notes if you can. That can also help with when you actually, if you do decide to make a complaint, be that informally at work or to one of those bodies that we've mentioned, that really helps in putting a timeline together to demonstrate that there are allegations that you're making and that's why you're seeking a response to them. Also important to keep copies of letters, emails, texts, anything that may also support that claim. It's quite rare that you'll find that there's independent versions of events that you can rely on. So it really does come down to your version of events and then subsequently what the perpetrator or the employer's version of events are. So that would be step one, is to just make sure that you do keep those records. Step two is seek support. It's a very stressful and distressing experience to go through, and be that through your GP, through your employee assistant programs, if there is one at work, or a counsellor or a friend, someone you trust. Really important to seek that support before really making sure, well, it's really important to make sure you are okay before you take steps to, say, escalate it. Your well-being is the most important thing through all of this. And so it's ensuring you're okay and you feel supported in taking some next steps. Similarly, if you say want to address this informally in the workplace, asking for help and also asking for copies of any kind of internal processes that apply if you think that you've been discriminated against or you think you've been bullied. Really important to have a look at, well, what does my workplace have already in place? And do I need to follow it? Is that something that they expect of us as workers? So it's important to check that whether or not those things exist. Again, as Fiona mentioned, they may exist, but they might not be very good. So if they're not suited and you don't feel comfortable following them, that's where I'd say maybe I need to start thinking about talking to a lawyer, talking to the union if you're a union member, to better understand what is appropriate to do in the circumstances. Sometimes things resolve informally by having those discussions with a manager, with a boss or HR or whoever the appropriate person internally is, but sometimes they don't, or sometimes you don't feel comfortable doing that. So in those circumstances, that's where it might be worthwhile considering, well, do I now consider making a complaint to one of those entities, be the AHRC, Anti-Discrimination New South Wales or the Fair Work Commission. And that's where I think it's really important to access these sorts of services that both Fiona, myself, Legal Aid offer, to ensure that you're picking one that works for you and is best suited to your claim from a legal perspective, and also then talking through what that looks like in practice to consider whether or not it actually suits what you're trying to achieve from the situation. Yeah, and I think those are the biggest things, and to reach out if you're unsure. People often come to us seeking advice, thinking something may be happening, but it hasn't yet escalated to a point they want to take action. So it's just really important to understand your rights in the workplace. And if they do intersect with other laws, say underpayments, dismissals, there's so many different elements to employment law that it's rare that we see them just occurring in an isolated instance. So really important to seek that support and these free services that are available if you're unsure.
Definitely, definitely. Thanks, Lucy. I'm sure a lot of people think if I take action about discrimination or sexual harassment at work, I'll be harassed by people I work with or lose my job. And what should I do then?
Yeah, we do see this a lot. There is a big apprehension to taking those steps because of what will happen if I do. And so I think the biggest thing that I could probably share today with the time we've got is that the Fair Work Act does provide protections to employees in workplaces under some principles called general protections. And these are things that employees are entitled to. It's your workplace rights, and that you're allowed to use them and should be protected when you do use them from any kind of adverse action or treatment in the workplace. So in theory, those laws operate that if you propose to take steps to make a complaint, or you do make a complaint at work, you shouldn't be treated worse off for doing so. And so that could be making a complaint about bullying, saying I witnessed something, or even I experienced something, or I feel like I'm being discriminated against, and seeking that to be investigated. Or when you actually do make a complaint and it's received by your employer, you shouldn't be treated worse off. You shouldn't be stood down without pay. You shouldn't be dismissed. You shouldn't be demoted. You shouldn't be put on gardening leave. That these things shouldn't happen because you exercised a workplace right. And so the Fair Work Act does have provision for that. And so if that did happen, again, it would be a situation where it's really important to seek some assistance and support, because it could give rise to a whole second set of claims that you may have to consider against your employer. I think the biggest thing to keep in mind with, if you're looking out for these things, or if you're worried, is that they can be really subtle or they can be really obvious. And so looping back to that question earlier about what to do if you think something's going on, that's what I meant by that. That's a universal approach of keeping notes and keeping records, is that it could then be applicable to another claim completely. Things that I often see in the people that we assist are hours getting cut really unexpectedly, being isolated, being moved out of the team is a very common one, being told you don't have to attend these meetings anymore, micromanagement of small tasks that may have never been micromanaged before, being ostracized, being forced to take leave, or being stood down without pay. Even though you're the one that made the allegations, you somehow end up being the one investigated. So they're all very common things that we do see in the types of matters we assist people with.
Great. Thanks so much for that, Lucy. I'm just going to you, Fiona. Who's responsible for preventing workplace sexual harassment and discrimination?
Well, our laws say that both workers and organisations have to prevent and address workplace sexual harassment. So organisations and employers have a duty under our discrimination laws and our occupational health and safety laws, and our fair work laws as well, to make sure that the workplace is safe. So that means that employers and organisations have to take all reasonable steps to prevent sexual harassment from happening in the first place. That includes having a really clear sexual harassment and discrimination policy, and making sure that all employees know about it and understand it. It includes having regular training for staff on sexual harassment and discrimination, and also having really clear procedures that people, and good effective procedures that people can follow if they do experience sexual harassment, so complaint procedures. And it also means that duty also includes leaders in an organisation or a business modelling good behaviours and not tolerating bad behaviours, not tolerating sexual harassment. So they, as I said, they have that duty to take all reasonable steps to prevent it from happening in the first place. And then if sexual harassment does happen, that employers also have an obligation to take appropriate action to address those issues. So again, like I just mentioned before, they need to have an accessible process for people to make complaints, like an effective process. And they need to action complaints in the appropriate way. So again, we've both Lucy and I have mentioned this a couple of times, I think, where what we often see is that the person who complains, who's been harassed, is told that they don't need to attend team meetings or they're moved to a different work site, whereas the harasser it continues to go to those meetings, or they don't get moved from the workplace. So that's probably not an appropriate way to action a complaint of sexual harassment. So employers and businesses definitely have an obligation, really strict obligation, duties on them. Also workers, everybody in a workplace and people visiting a workplace, whether that's clients or patients, etc., patients in a doctor's surgery, that they also have an obligation under our laws not to sexually harass others, to follow. All employees have an obligation to follow the policies and procedures that their employers have, which should include not sexually harassing other employers. And they also have an obligation, employees have an obligation to report sexual harassment that they see or hear about.
Great, thanks for that. And Fiona, is there a particular group of people who is more affected by sexual harassment in the workplace?
Yes, I mean, generally, I would say I would acknowledge that sexual harassment happens to men, but I would also say that the majority happens to women, that it's mainly women who experience it in the workplace. And I guess I would refer us back to the Australian Human Rights Commission Respect at Work inquiry, which was done in the last couple of years. And basically what that report found, that inquiry and the report details, is that the groups that are suffering it the most tend to be young workers under 30, workers in casual or precarious employment, so casuals, people with a disability, people from culturally and linguistically diverse backgrounds, people on temporary visas, LGBTQIA people, and have I missed any? And Aboriginal and Torres Strait Islander communities. Lucy, jump in if I've missed anybody there. But generally, that's what the report found, is that they're the most vulnerable groups, and they're generally the groups that are suffering the most discrimination and harassment, and also the least likely to get legal advice and legal help and to do anything about it.
Yeah, I think you're spot on there. I think, and speaking just from what we see and who we help day to day, those are the community groups that we more often than not are assisting. So I think what's in that report does speak true to what's actually being seen on the ground as well.
Great, thank you. So we're now going to wrap up the panel discussion and begin the Q&A part of the webinar. So just looking through, we've got a couple of questions over here. So Fiona, what happens if someone has been discriminated against or experienced sexual harassment in the workplace, but the other party denies their actions due to the power imbalance and says that the employee is simply lying? And I guess this kind of touches on what you said, Lucy, to have, those records and keep those emails and that sort of thing.
I would say that the scenario described is generally how it happens in all cases. And in fact, I've been helping people with these cases for over 20 years, and I can't say I've ever seen it happened differently where there's not a denial. And so I would say that I don't think it matters. I mean, not that it doesn't matter where you've got two people, one person saying something happened and one person denying it. But most discrimination and harassment that happens in private or is not witnessed by other people, or there's no independent evidence of it happening, and it's one person's word against another, and that is totally fine. It's fine, and it should not discourage people from coming forward and getting good outcomes.
Yeah, that's true. Lucy, we've got a question here. What should my 16-year-old do if their employer is not paying him correctly, but he's scared to question it in case he gets sacked?
Yeah, fair question. It is one of those things, as I touched on earlier, under general protections that the Fair Work Act provides for, is that you're allowed to make complaints or inquiries in relation to your employment. That includes the terms and conditions of your employment. So if you think you're being paid incorrectly, it is one of those things that you're able to go to your employer, and you are protected when you ask, is it correct? Can you please confirm it? Can you please look at this? I've found this online and I think my pay rate is actually different. So good to do some research of your own first. The Fair Work Ombudsman has a fantastic website with calculators that you can put in what your job is, how old you are. It can tell you what you should be paid to the best of its abilities, being a form, but they also have a hotline that you can call to confirm your rates of pay. If you did say raise that at work and then your employer did turn around and fire you or treat you worse off because of that, that would be a situation where I think it's really important to get some free legal advice. You can call Law Access. You can call any of the community legal centres. Best to try and find the one that covers you just to minimise time. But otherwise, they can refer you to the right one. And then from there, seeking some further assistance as to how to navigate that potential dismissal. And also the underpayment if it does exist.
Thanks, Lucy. Lucy, we've got another question here. What must an employment contract include, or what are the main features that an employment contract should include?
So this is probably a bit of a tricky one to have one answer to, because employment contracts do create themselves in various different ways. It can be verbally, it can be written, it can be in an email, or it can be in a full-fledged employment contract. So employment relationships can be created in many different ways. Best case, they're in an employment contract that sets out all of the terms and conditions that navigate the relationship you're entering into with that employer. But the things that you'd really want to ensure that you see in there is the type of employee you are, be it casual, permanent, full-time, part-time, or otherwise. You'd want to see an hourly rate or an annual salary. You'd want to understand what your rights are, say if you do have an issue at work, or if you decide you want to leave, or the notice periods they expect. You'd also want to understand what your job is and what they're expecting of you in holding that role, be it a position description. What we recommend is if you do receive some offer of employment and you're unsure of it, or if you're not sure if it is in fact lawful, really important again to get that legal advice with a number of different free services that are available to do that.
Great, thanks, Lucy. Fiona, we've got a question here. What about women returning to work after mat leave or pregnant employees? Do you see them treated, what if they're treated unfairly? How can they know their rights?
Well, we see, as I said, we see this all the time. We shouldn't, but we do. Well, I mean, I can't say it's always unlawful discrimination, because it depends on the factual circumstances. But what I would say, my answer to this is my answer to the question about what anybody does about if they feel they've been treated unfairly at work in any way, is to get some advice as early as possible. As Lucy said, there are lots of community legal centres, Aboriginal Legal Service, Legal Aid. All of us provide free legal advice to people, and the earlier you can get advice about your particular situation, the better, because these are really complicated. These are really complicated laws and legal systems, and there might be a whole lot of different legal options available to you. And so if you feel you've been treated unfairly, women returning to work or in any other situation, get some legal advice. as soon as you can, and do all those practical things that Lucy talked about earlier as well, in terms of making notes and keeping records. Whatever you can is going to be helpful later if you do decide to take some sort of formal action. And I'll just add to that like as lawyers, if you're coming to us for free advice, then I mean, obviously we'll talk to you about all your formal legal options, all the things we've talked about today, making formal complaints. But what we'll talk to you first of all about is what you want to achieve and what outcome you want. And if that's keeping your job and getting your pre-maternity leave job back under the same conditions with the same pay, or whatever it is, whatever you want to achieve, then we're going to give you advice based on what you want to achieve and how you can achieve that. And that might be, it might be something as simple as writing a letter to your employer saying, this person has come to see us, this is what they've told us, what you're doing is against the law, we need you to do A, B, and C to fix this situation. And that might be enough to resolve it and to sort it out and to get you to keep your job or whatever else it is that you want. So there are lots of, like, it doesn't have to be making a formal legal complaint or going down this long legal pathway. There are some quick and easy ways to sort things out and get what you want with some support and help.
Thanks, Fiona. Lucy, just going to you. What actions should employees take when their small business employer has failed to make the legally required superannuation contributions for them?
So superannuation, I'm just conscious of time, is a very, very big area of law that does intersect with the ATO as well as with your employment rights. So I think if you've got concerns about a superannuation issue, it would be best to reach out through Law Access or through CLC New South Wales to find your local community legal centre or get some free advice as to how to navigate that.
Thanks, Lucy. Lucy, is it unlawful for an employee to be given work that's very different from the job description that was advertised?
It's not necessarily unlawful. It does depend on the type of work that you are in that employment relationship to undertake, as well as your skill set and experience. If you feel that the work that you're being asked to undertake is unsafe, or there are limitations in your experiences to being able to safely do that work, again, I think it would be really important to seek some legal advice on that, because a number of factors weigh into that, be what's in your employment contract, what your skill set is, what they're asking of you. Unfortunately, there's no blanket answer to that one.
Thanks, Lucy. Fiona, just going to you. So we've got a question here. Many times people do not speak out at work about discrimination or sexual harassment because they're usually asked for a referee from a previous employer. How does one go around that?
That's a tricky question. I mean, we understand that, you know, the realities of life is that, and okay, so what I would say is that one outcome that people ask for is a written reference. And if you get a good written reference, then there's hopefully going to be no need for your future employer or your prospective employer to go back to that past employer and get any sort of, to speak to them at all and get any sort of verbal reference. I mean, if you show up with an amazing written reference, then hopefully that's enough.
Great, thanks, Fiona. Lucy, is it okay for employers to pay a temporary employee lower than the permanent employee who usually does the job?
I feel like I might be repeating myself here, so I do apologize for that. These are very complex laws that govern the type of employee and the way that you're engaged and what you get paid for that engagement. Casuals naturally get a 25% loading, but it would depend if that person has been potentially classified as an independent contractor or an employee. There's even further laws that kind of sit around that, because sometimes it's called sham contracting. It would be something that I think, if you're unsure of the rates that you're being paid compared to your equivalent employee who may be permanent, that it's really important to get some legal advice on your situation and what your rate of pay would be. Just because someone else is paid differently, we just don't know why that might be the case. So it is very much a case-by-case basis to better understand what you would be entitled to receive as pay.
Great, thanks, Lucy. And just the last question, Lucy, is it okay for a contractor's salary to remain the same over a number of years?
So contractors, if they are truly independent contractors, are not necessarily classified as employees. So again, it would depend on the analysis that needs to kind of be undertaken, depending on why they're the contractors, why they're not employees, what they're doing in the role, how much control that employer has over the person in that role. If it's negotiated and say it's quite generous and it's stayed the same for 5 years, it's not necessarily breaking a law. However, if it's not generous and say it's below the minimum wage and they're actually an employee, it might be quite problematic. So because this is such a complex area of law, particularly with underpayments and whether or not you are or are not an employee, I think really important to even the Fair Work Ombudsman is to reach out and get some information and some advice on what you may actually be classified as the law sees things, not what your employer sees.
Definitely. Thanks, Lucy. So that concludes the Q&A part of this webinar. We're now going to move on to the next slide for more information on where to get help. As I said before, the recording of this webinar will be available on our YouTube channel. There'll also be an evaluation survey at the end of this webinar. We would greatly appreciate your feedback. And I believe the handout that I referred to earlier is also available in the chat for you to download. So just to let you know, tomorrow we will be running a webinar about debt and the law in our Lunch and Law series. If you're interested, you can register via the Law Week New South Wales website. I'd like to say a really big thank you to our panel today. Thank you to Lucy and Fiona. It's been great that you've been able to share your expertise and knowledge with our audience today.
It's my pleasure.
Pleasure.
Thank you for having us.
Yeah, pleasure. Thank you. And thanks to everyone for attending, for coming.
Thanks. So we'll close the webinar now, everyone. Thank you for attending and goodbye. Goodbye, everyone.
Thank you. Take care, everyone.
Bye.